that can occur.
Okay, so Necetta is special in that sense.
It's almost a code, if you like, for Transpower works, which it covers.
Understood. Thank you.
Thank you, Ms. McIndoe. You'll be pleased to hear I've only got a couple of questions. But I do make a general observation around your introduction about why you've set out Transpower's key matters. And I think your key chapter is going to be chapter 11, where most of the evidence will come through. But certainly really appreciate you setting those out. Your observation about the fact that generation's changing all the time. We seem to be on the cusp of quite a significant change. Power companies are closing down gas-fired power stations. Otahuhu is closed. Stratford, or what do they call that now, may not last much longer, and we may be moving to we will be moving to a more of a renewable energy generation portfolio. And we've heard already in this hearing about possible offshore wind in Taranaki. And given the fact that some of those, or a reasonable portion of the offshore areas in Taranaki may all need to come through ONFLs, as we've heard. You've actually, depending on where things are actually located. So the grid is you follow the generation. So that's means we certainly appreciate the importance of setting that out for us. And in terms of making a new plan, New Plymouth District at the moment, it is a very important future planning issue to have on the table. So appreciate you doing that.
Ms. Rebecca Ing's evidence for the strategic directions provides even more detail on that. So if that was a matter that was important, then could go
and I did
evidence.
make a comment to the other council when I'm deliberating and doing decision writing. The lawyers' submissions are very, very helpful, just the way you set things out, and with the background and relating it back to the provision. So again, really helpful. My two questions relate to, one is a bugbear of mine, which I'll get your opinion on, 4.3, and this is the fact that we have in National Planning Standard. That's the document that we the council has to be occurring, has to comply with. But then the government keeps coming along with these guidance documents seeking to explain what they mean. Sometimes at the same time, sometimes quite a bit later. So you're seeking to take advantage of a guidance document that's not the planning standard. That's how MFE suggests it might be interpreted. I suppose my bugbear is, policy statements, standards should be able to be read on their face, just like a statute.
And I accept that. And you probably are aware of the King Salmon decision, where the court said, we don't care what the guidance on the New Zealand Coastal Policy Statement says. This is what the words say, and the New Zealand Coastal Policy Statement. So guidance is just guidance.
Yes, yes. And we've heard quite a lot of evidence sort of relying on guidance or pointing to guidance. So the primary documents are ultimately what we are driven by. Just a question, putting that aside, are you suggesting in 4.3D that the network utility chapter might be seen as a special purpose zone in the way that that's defined, or am I misinterpreting that? No,
I'm not suggesting that. I'm suggesting that the national planning standards themselves are conflicting in their direction. And so trying to help you understand what do you do in that situation. That's when I went to the guidance, and the guidance says that you should locate everything in the energy, infrastructure and transport heading unless it's a special purpose zone, and I'm not saying that this is a special purpose zone.
Okay, I gotcha. That's how I understood it. Look, my other question really, it's a procedural matter, or what I call is a procedural problem for us. You have signalled that you've gone $1 each way, I suppose, but you have backed a winner, hoping that, you know, we will actually go down that path in terms of the interest of your client. You did say that if we didn't go down that path, you want to come back to us with some further provisions and evidence. And I'm just trying to work my head around how that might be organised, because we're hearing your main topic around hearing number 11, and then we're not planning to make any more interim guidance or make any decisions until we've heard everything. So can you help me with that procedural problem, whether you've got any suggestions that might help us plan ahead?
So my thought was that if, after hearing the evidence and submissions today, you thought it would be useful to see what the alternative drafting might look like, then we could provide that by, say, the end of the week before your hearing concludes. Then you would have both sets available to you. But if you thought that would just add to the paper trail and you understood our points clearly, then you might find you don't need that, and we would continue to back our horse.
Okay. But, and I may be getting this wrong, but the fundamental point is that you'd like the key policy at least in one place in the plan. You'll be making further submissions and probably have further evidence at hearing 11 around network utility. So we won't have the benefit of that, or do you think we've got enough to make a call and say, look, on balance, we're not, because we won't be deliberating on this until we get the right reply from the staff, whether any other commissioners could help me about how we might set up a process. The safest thing would be to just give us the alternative anyway, just because it's uncertain, and we will be thinking about deliberating as we go, but then we won't be issuing any final decisions until the very end. So whether any other commissioners had any comments about that, or whether you did?
Sir, through you, I'd certainly prefer to see the dollar each way approach rather than on the nose. So if you can provide those alternate provisions, because I'm not certain I've captured them in my mind entirely, what they are. So just having them laid out in black and white would be, or colour, would be useful.
Yeah, we're happy to do that. The evidence for the energy hearing would be dealing with additional matters. So it would cover Transpower's works in the district and the importance of the national grid, as well as dealing with matters of electrical safety and supporting Transpower's requests for the national grid yard and corridor, which operate to regulate third-party activities. It would likely also describe Transpower's options assessment process, and I guess that could be useful for your deliberations here, but I don't think it's essential. Just reading the policies on their face is probably enough, I would submit, for you to be able to understand how they would sit in the chapters.
Yeah, that's useful, because what I'm getting is that you've got a very strong preference to have the policies in the utilities chapter, but if they are to be split, they need to be clear. But you're more relaxed about where the rules end up.
That's correct.
Yes.
Okay, well, let's proceed on that basis. I'm just thinking that will take a bit of time to put together.
It would take some time. I'm looking at Ms. Rash on the screen. I expect we could probably get that to you, say, by the end of this week or early next week, perhaps.
By Monday, would that Monday lunchtime, say?
That should be fine.
I can't see Ms. Rad. Is she nodding or grimacing?
She's laughing, but I'm sure we could do that.
That's probably hysteria.
Yeah.
Okay. Look,
Monday lunch.
it has been quite a reasonably long discussion, but it is important that we do have these discussions. And I said to someone earlier, we don't apologise for having these discussions because, you know, they are important matters for your client and for the council. So thank you very much.
Thank you. Now, I was going to leave Ms. Ratt to present her summary. She's got a summary statement.
Thank you.
And tēnā koutou, commissioners. As you are aware, I have prepared a summary, but I won't read it verbatim, so I'll skip across the main points and direct you where I'm reading.
Thank you.
So as Ms. McIndoe has alluded to already, the basis for many of Transpower's submission points is the NPSCT, and as she's already said, Policy 8 is particularly relevant to this hearing. So I support going down to paragraph 2, I support Transpower's request for a suite of provisions to be included in the Network Utilities chapter, and I concur with Ms. McIndoe that that would be, to my mind, the most efficient approach. So going on down to paragraph 3, as Ms. McIndoe has already said, many of Transpower's activities are regulated by the NESETA, and she set out the nuances and the application of that. So going on down to paragraph 4, so I've just done a highlights package on each of the provisions to complement Ms. McIndoe's legal submissions. So starting with NFL P3, I consider that NFL P3 needs to enable minor upgrading, as well as the reasonable operation and maintenance requirements of the national grid, and that's to give effect to policy 5 of the NPSCT. And as Ms. McIndoe has already said, she stole my thunder quite a lot, is that policy 8 of the NPSCT has that seek to avoid adverse effects direction. But that direction only applies to planning and development. There is no similar direction when carrying out minor upgrading. So going on down to paragraph 5, in terms of NFL P5, clause 5 will be highly relevant to any planning, development or upgrading of the national grid in an ONFL, as NFL P3 only applies to existing structures. And while I support the recognition of the operational, technical and functional need to locate within an ONFL, I cannot see the purpose of the last part of the clause, which states whether it is an anticipated feature of the environment. Going on down to paragraph 6, and that's policy NFL P6. The policy uses the word minimise, but it's not clear what this means in the context of the national grid. And I support amendments to recognise the technical and operational constraints of the national grid and the extent to which those aspects limit the ability to minimise prominence or visibility of national grid structures in an ONFL. So going on down to section 2.2, that's where I talk about the provisions specific to the eco chapter. And in paragraph 7, as I've outlined in my evidence, I support the concept embedded in eco P1 of identifying and mapping areas of significant Indigenous vegetation, SNAs, and that these areas are mapped, and that forms the basis of the SNA provisions. And my recent experience with Waikato's district plan has highlighted the complexity if you go away from that approach and have SNAs applying wherever they meet those criteria. It's really problematic. Going down to paragraph 8, and that's objective eco 01. So I support amendments to clarify what the areas of significant Indigenous vegetation, excuse me, and significant habitats of Indigenous fauna are to be protected from. To my mind, this gives better effect to RPS Biopolicy 2 by recognising that some use and development is appropriate if effects can be appropriately avoided, remedied or mitigated. And I am aware that I've got some searching questions coming from Mr. Littlejohn. Going on down to paragraph 9, that's the consenting pathway for significant infrastructure, namely Eco P3 and Eco R1. I support Ms Macbeth's recommended changes to Eco P3 1B to recognise the operational and functional constraints of regionally significant infrastructure. And I'm sure you guys are already aware of this, but that difference between what's in Appendix 1 to her Section 42 report versus what's in the body of that Section 42A. And I rightly or wrongly, I'm not sure, but I've assumed that the Appendix 1 to that Section 42A report is what was intended. I also support the explicit recognition of vegetation clearance for the purposes of operation, maintenance, repair and upgrading of existing tracks and infrastructures in Eco P3 1A, as this would include network utility structures. But I do think that the start of the policy would benefit from redrafting for clarity. And it seems from your questions that it seems to be a similar problem for Eco P4 as well. And that the start of the policy is not clear as to what it's actually pertaining to. So going on down to paragraph 10, with regards to Eco R1, I do not support the non-complying activity status for National Grid activities which are not permitted. I would support a less stringent activity status to recognise the importance and constraints of the National Grid and or regionally significant infrastructure. And my evidence suggests a restricted discretionary activity status for Indigenous vegetation disturbance for new National Grid infrastructure and associated tracks. And I noted your questioning of the previous witnesses for trust power. I certainly concur with their thoughts on why the advantages to a restricted discretionary activity versus a non-complying. Going on down to paragraph 10.2, I support the inclusion of operational or upgrading in the list of activities associated with network utilities that enable Indigenous vegetation disturbance as a permitted activity. And at 10.3, I support enabling the disturbance of Indigenous vegetation in order to comply with the electricity hazards from trees regulations. So this activity is carried out by landowners as well as Transpower. And my evidence suggests a new clause 9, which would allow vegetation disturbance for this purpose. Now, there is a typographical error in there. I had operation twice. But the other thing is that what I haven't done here, and you may have a preference to insert it instead, is I don't actually have a reference to that regulation in that clause. And perhaps if we did include it, it would be clearer that that was the intent. But I guess that the thing is that regardless of whether it's Transpower undertaking, the trimming, or whether it's the landowners, the intent of that regulation is to keep the National Grid operating and safe. So going on down to paragraph 11 and biodiversity offsetting, including the definition, I do not support Ms Macbeth's recommended changes to Eco P4 to require all more than minor residual adverse effects to be offset, and consider that Eco P4 should require only significant residual adverse biodiversity impacts to be offset. And the basis for that is to better match the guidance or good practice biodiversity offsetting in New Zealand. And going on down to paragraph 12, the definition of biodiversity offset. For similar reasons, I do not support the deletion of references to significant and no net loss from Eco P6 clause 2 and the definition of biodiversity offset. I also consider including Indigenous in the definition will give better effect to RPS Bio Objective 1, which seeks to maintain and enhance Indigenous biodiversity. And from memory, I obviously was colourblind at one point, and when I've done my track changes, I think I put the inclusion of Indigenous as blue, not red. So just be aware of that. And in terms of Eco P6, paragraph 13, the effect of Ms Macbeth's recommendation for Eco P6 clause 4 is that highly irreplaceable or vulnerable biodiversity cannot be considered for compensation. And the changes that she's recommending somewhat conflate offsetting with compensation. So given the operational and technical challenges for the location of the National Grid, I support retaining a broad range of options for managing effects. I'm happy to take any questions.
Before we go to questions, can I just clarify that the colour issue, where exactly that is in your Appendix A?
Sure, it is the definition of right down the bottom of the rainbow of provisions.
Definition, yes.
Yes, so
Okay.
it's the definition of biodiversity offset, and so you've got Indigenous in the
Yes.
blue,
There should
that should
be
have been red.
There should be red.
Yeah.
Thank you. Right, I think perhaps before we go to questions, Ms. Macbeth, did you have a clarification for us?
Yes, just at the introduction to the hearing, I acknowledged that error that Ms. Spratt has pointed out, and the wording that I intended is correct in the appendix and incorrect at paragraph 191, I think it is, of my report.
Yes.
Thank you. That's really helpful.
Thank you very much. So Commissioner Littlejohn.
Well, I think I've already asked my questions, Caroline, so I guess I'm just looking for your answer. I did go and have a look at the RPS policy that you were referring to there, and it merely says adverse effects on Indigenous biodiversity in the Taranaki region arising from use and development will be avoided, remedied or mitigated as far as practicable. So there's no real hint there of appropriate activities. So I just, what else can you tell us that might support, from a statutory perspective, the insertion of these words into a policy that's, doing the heavy lifting for Section 6C?
Sorry, were you talking about the objective or the policy?
Objective.
Oh yeah, cool, I thought so. It is a bit of an awkward one because, of course, Section 32AA and refers to Section 32 requires us to assess the objectives against the most appropriate way to meet the purpose of the Act, which, as you're quite correct, doesn't, that Section 6C does not have those similar words, it just has protect. However, we in Section 75 also have a requirement to give effect to the RPS, which inherent in that the RPS should be giving effect to the purpose of the Act. But to me, that biopolicy policy 2 in the RPS, the way that that's drafted doesn't make me think that everything should be protected. It makes the way that it's written, the way I interpret it anyway, is that the use and development of natural and physical resources will be avoided, remedied, or mitigated as far as is practicable. So yeah,
to the extent that might conflict with Section 6C, which one do we give greater weight to?
That's awkward, isn't it? Because we're
no,
required
there's a
to
simple
do
answer. Well, there's a simple answer to that, and it can't derogate from the statutory provision. So, and of course, I think everyone's acknowledged that aspects of this policy statement in this space are rapidly becoming outdated with policy developments and court decisions, indeed, over the last decade. So, well, I don't think I can take that much further. I take your point that there's potentially two different policy obligations that have to be met, and one of them seems to be suggesting a more of a nuanced approach than an absolute approach, and I think we'll have to grapple with that ourselves. I mean, apart from that, I have become very confident in your evidence, given the number of occasions you've presented it thus far, that it covers everything. And I didn't have anything else particular there. You've raised some issues and provided a good basis for us to deliberate on. So thank you. That's all I can say.
Thank you, Commissioner Coffin.
I just had just one matter of clarification. Was that a matter you raised in regards to paragraph 7 of your summary, and you had supported the concept in Eco P1 in regards to identifying significant natural areas, in contrast to the Waikato example that you mentioned, and I think you laughed, and I just wanted to interrogate. I haven't been involved in a significant way in that particular hearing, but I was just interested was the issue about implementation of that, or if you could provide any further details?
Of course, yeah. So I will provide you with a little bit more just the context to describe what went on there. So the Waikato Regional Council, feedback's really bad. The Waikato Regional Council provided the data to the Waikato District Council for the SNAs, and it actually turned out to be highly inaccurate, like not even a little bit, like massively inaccurate. And so the Section 42A author looked at that and went, oh, what are we going to do? Because that's so wrong. And so she recommended that we revert to the definition. And so that any areas, any tree that met the criteria which matched the RPS, and is very similar here, automatically became a significant natural area. Now, what evolved out of, became apparent during that hearing, particularly from the likes of Federated Farmers, and they've got a very good point, is that because, and just using these as an example, anything that's kānuka or mānuka, because of its threatened species, suddenly, because of its threatened status, I should say, suddenly became an SNA. And to top it off, in the Waikato, I'm not sure whether it's as big an issue here, we've got long-tailed bats. Now, they're a highly mobile species. So again, wherever they were located, that suddenly became an SNA as well. And I'm also aware of I think it's a copper skink. That's the most emergent species that's been reclassified. And same problem, suddenly wherever that species is found, it's suddenly an SNA. And the problem is that it's not actually, with those particular species, it's not contained to Indigenous vegetation. Both of those species are in exotic species as well. So it becomes very difficult to manage.
In the breadth of the coverage of the SNA definition. Okay, I'd worked on the Rotorua district SNAs, and we had some of the Waikato district region was in the Rotorua district. It was quite an unusual situation. We had an overlap of two regions in a district. So I'm familiar with what you're describing there. So yeah, thanks very much.
Commissioner McMahon.
Good morning, good afternoon. Sorry, it's been a hang of a day.
Long day.
Las Vegas, we don't know it's day or night outside.
And there's no clocks. It's like a casino. There's no clocks. And yeah, not that I know much about casinos. But just an observation with your colour blindness, it's probably a good job that you're a consultant to the electricity industry and not an electrician. So,
yeah, I reckon I would have fried myself.
Because of what the chair's about to say, I've really only got one question, because I think the process that he's going to outline will be one that'll be assistance to all parties. But I just wanted to ask you about your paragraph 7 of your summary, Ms. Rapp. And that's about your very clear point about defining SNAs and including them on a map. And as opposed to having a process that sort of defines them on the hoof, so to speak, presumably during the consenting process. And you referred to your experience in the Waikato on there, and I'm interested to hear a little bit about that, because earlier submitters, I think particularly the Director General of Conservation and the New Zealand Rural Forest and Bird Society, have suggested that we perhaps look at that alternate approach. And I just wondered if there are any sort of advantages or pitfalls that you can draw our attention to, and based on your Waikato experience.
Yeah, I've noticed your comment that it's around consenting, but it's actually much broader than that, because the issues don't bite necessarily in consenting. They bite for anybody who's got one of those particular species, and that species is constantly changing. You know, the criteria is whether it's been listed as a threatened species, and they're constantly being updated. I mean, 10 years ago, we would have had no idea that kānuka mānuka, for example, would be classed as being threatened because of the potential risk of myrtle rust. And probably same with the copper skink, we didn't know that that was going to become an issue. So I think enforcing it, just speaking honestly, it's a complete, that approach is a complete nightmare for council. They can't enforce it because they don't know where these species are, and they don't know until it's actually gone, which makes a bit of a nonsense of the district plan. And for landowners, you know, we especially with the highly mobile species, they can go anywhere, and it's not just Indigenous vegetation that's their habitat, from my understanding.
Okay. The converse of that is during the consenting process, whether there should or shouldn't be an ability to, I guess, recheck the validity of the boundaries and to determine whether there is actually presence of vegetation that meet the criteria in the policy. And to that extent, and I think this is what's intended, clause 8 of ECO R1, I don't know if you've got that in front of you.
Was that one where it said if it didn't meet the criteria?
Yes.
Yeah.
So it's the reverse of what I described earlier about adding to on the hoof. This is deleting on the hoof, so to speak. Have you had any experience with that?
No, I haven't seen that before, but I would support it because I think it is very useful. Depending on and I can't speak for New Plymouth District Council, but depending on the level of detail and accuracy of their mapping, I think it enables area, you know, that to be more fine-tuned without needing to go through a Schedule 1 process. Obviously, you'd want to pick it up at some point in time. But I think that I would totally support that clause 8 to ECO R1.
Right, then that's all from me. Thank you.
Yes, thank you, Carolyn. I think you followed our requests to the letter in terms of the way you're presenting your evidence. The clear section 32AA and Schedule B. Really appreciate it because that helps us so much. I don't have any particular questions. I found your evidence very clear. And the thing that I am going to say is we've been toying for a few days about the idea of expert conferencing, particularly around the ecosystems and Indigenous biodiversity with the planners. And I've posed that to Ms. Macbeth, and I've posed that to some of the other key parties with, you know, experience, planning expertise. I've come to a conclusion I do think that would be beneficial to us and would request that Ms. Macbeth organises that. The timing of that would be, there's two questions. One is around timing, and one is whether there will be any merit in extending that to any of your chapters as well. The contests on some of the big issues are in your space, I think, Ra, but whether you could give us some initial feedback now on that.
The concept of expert conferencing?
Yeah, I'm asking the staff at the moment, and I'll come back to you, Carolyn. Yes.
In terms of the right of reply, if the right of reply and the conferencing were due 2 weeks after the
Close.
verbal,
yes,
that would be a very tall order. I think I've got a lot of things to provide a written right of reply on, and potentially you'd want to do the conferencing first, finalise.
Yes.
So certainly would appreciate an additional week or two to allow the conferencing.
Well, given the importance of this to us, we'd be happy to accede to that. And so that's one question on timing. Denise, in terms of your chapters?
I was thinking potentially with the port and developing maybe she talked about a bespoke policy around Makatahi if we were, I'm not quite sure if that's something that the commissioners were thinking about or whether that would help or.
We don't have many of our iwi people here.
Yeah.
But I wonder whether you could make some inquiries about that, because the way our procedures are set up, you know, this can happen voluntarily. We can direct. Sometimes, in my experience, these things become so obvious that it's obviously going to be helpful. But again, thinking about you and your position as reporting officers on complex topics, certainly interested in your advice on that, Denise. Maybe you could talk to us again early next week when we reconvene on Monday.
I do need to hear the evidence first.
Yeah, so let's leave that one until after we hear the evidence. But certainly I think we can start preparing for the chapter that or the block of work, I think, Ra.
Yes, I'm happy to proceed with
yes.
arranging a
appointments and perhaps come back to us on Monday with a suggested timetable, because everyone's busy. We've got the benefit of some excellent experienced planners advising on this, so we get a lot of value with that. But coming back to you now, Carolyn, just any thoughts from you?
In my experience, I found that expert conferencing is really helpful. And I think if you can't reach agreement, at least you can define what the issues are and the areas of disagreement. So I think it's quite useful for narrowing that, even if there isn't agreement.
Yes, and we'd want it to be written up on the basis that there was agreement. And if there's any reasons for that, that's useful. If there's disagreement, who disagrees and why not? Because we're not driving towards consensus here, unless it does make sense. But I see there's a lot of similarities in the thinking between a lot of the planners, and we'll certainly have the doc planner involved. They were quite keen on this when we spoke to Ms. Yosen, and they're promoting this other idea about district-wide rules with some sort of criteria that captures what's not in the SNA. So we'll see all sides in the conference. So yes, and I don't think, given the experience of the planners, we need a facilitator. I think if you can just organise that amongst yourselves, and we'll confirm timing in those matters on Monday.
Yes.
And Denise, if you can, we'll have a think about any of your matters that might benefit from that after we hear from the iwi. Thank you. Thank you very much. We don't have any other questions for Transpower.
Thank you for your time.
Thank you. Thank you, Nikki, and thank you, Carolyn. Right, Ms. Johnson, I think we're moving to you. Thank you for your patience.
Good afternoon.
Good afternoon.
So my overall submission predominantly relates to functionality, clarity of the plan. In the evidence that I provide to the Commission, in the majority of cases, I agreed part with the recommendations. In some circumstances, suggesting some additional wording that I felt might add clarity. As a practitioner, I find it far more efficient if you don't spend 2 hours arguing with somebody over what the wording of a policy or a rule actually means. So it would be good to get it sort of process. And for that reason, I didn't feel that I needed to address or raise any points, particularly with the Commission, but that I make myself available should the Commission want to ask me any.
Thank you. Did you read our minute that we issued on the expert witnesses and obligations to appear before us?
That's why I made myself available. I didn't feel the need. I felt that the evidence that I provided said everything that I needed to say,
yes.
But that if you wanted to ask me some questions, that I would be happy.
Yes, and that was our decision. I went around the commissioners and they did have questions for you. So you understand that you're here because you're an expert, you're under the code, and we have questions. So, and we've issued a specific minute about that. So that's why you're here. So thank you very much.
Yeah, I do understand that. I just queried when I put my submission in whether you actually would want me to appear on.
Oh, so you asked us the question.
Yes.
Yes. Yes, that's right. And I think the question, when I went around the commissioners, that yes, they did have questions. So thank you for being here. Is there anything you'd like to summarise, or we've read your evidence? Just here for questions?
No, I don't think so. As I said, the majority of my evidence relates to just suggestions as to how additional clarity provided.
Okay, so Commissioner Littlejohn.
Yeah, I do. Thank you, Ms. Johnson, for coming along. And I think I might have mentioned this at one of the earlier hearings. It's always good to have someone who's got their fingers in the middle of these plans on a daily basis to reflect on how they should work. I do caution you about saying that you want a plan that people don't argue about, because if you achieve that, then most lawyers in this field will be out of a job. So we've got to keep some problems there. Let's just be clear about that. So I'm interested in subdivision and incentive-based subdivision, and I'm interested in it because I've spent quite a bit of my practicing career in the Auckland region arguing about whether landowners who wish to retire land and plant it and restore it with native vegetation should be given the benefit of additional title rights for it. And I mean, I'm not sure if you're familiar with how this concept evolved, but sort of in the late 90s, there were cases like Arigato, the infamous Parkery Hills plantation case, DeAndre Estates and the like. And I mean, these are cases that I've sort of lived and breathed for most of my practicing career, which have led in the Auckland region to incentive-based subdivision provisions that reward landowners for retiring land that's not good for farming by planting it out, and rewards them with additional titles. And I mean, I've been to the High Court several times on how these rules ought to work and the like. So that's a really long-winded introduction for me to sort of find an approach in the new Plymouth District Plan, and I was interested from the outset to see whether there was such a thing. And I guess my first question to you is, dealing with landowners and their aspirations for land in Taranaki, have you come across landowners with an aspiration to retire and replant, but for whatever reason, the absence of any sort of incentive to do so has put them off?
So I've been working in the Taranaki quite some time, including on the SNAs for the Plymouth District Council. My experience is that it's not the lack of an incentive. In fact, when we visited one SNA landowner, they referred to the incentive or the protection of SNAs and the ability to additional allotments as a bribe. So it's almost the flip side, where people perceive the thought that they might be regulated through some of their action, where it acts as a disincentive, if you like. So I don't know if I've explained myself completely clearly there, but there has, under the operative plan, there was some uptake, but the rule wasn't necessarily as clear as it might have been. So it possibly wasn't as utilised as it might have. But on its own, we found that people who want to protect bush will protect bush. And they generally take pride in the fact that it's still there. They've managed it. They've kept it. It's through their actions and not through regulation that it's still there. And so it's more a case of they see regulation as not recognising stewardship that they've put in place for the areas. And so any form of regulation, I guess, is seen as some way of wanting to control what they do and it can have an adverse effect, even though you're intending it to be a positive, as is the case with the developments.
That's I must say that's certainly my experience, and of the evidence, some of the evidence we've heard to date, and certainly my experience with other regions around the country. In terms of, I mean, the starting point is obviously to protect what is there. We've got a plan, though, that at the strategic level aspires to restore. And I've taken that to mean that doesn't just mean restore and make healthier that which is left, but also potentially to increase the extent of cover so that it's closer to what it might have been originally. And that's where this notion of replanting has very much taken off in the Auckland region. And I guess my question is, has anyone expressed any interest in doing that? I mean, have you come across that as an aspiration of a landowner in the New Plymouth district to actually go beyond just protecting what they have and actually trying to retire and increase the area of cover on their property?
From memory, I believe that there have been cases in the New Plymouth district where they have had aspirations to retiring and planting, and that they do see themselves as the stewards of the patriarchy land. But there is that nervousness about what that replanting then means in terms of rules that might regulate their ability to remove an area, a portion of what they've done for whatever purpose. They then get into the potential for controls on them. And so those potential for controls are disincentives.
Yeah, okay. Well, I mean, I don't perceive that any submitter has actually asked for an incentive mechanism to that extent. So, I mean, except we're not in a situation of that even being an option. But it is something that I'm going to follow along in the context of the subdivision rules chapter as to what such a proposal might look like if someone put it up. I guess then coming back to what you're suggesting in terms of the tweaks to these two rules in the eco chapter, Ms. Macbeth's clarified through a substantial sort of rewrite to eco, which one was it? Eco 5, that it really is just going to operate as almost like a standard, that if your site has significant an SNA on it, if you are subdividing it, then certain things need to be met when you do that. So do you think that's an appropriate approach?
I think it's consistent with the approach that we've got in the operative plan, where essentially an SNA, as Councillor McMahon referred to earlier, is an overlay.
Yep.
So you are adding additional requirements that recognise the specific characteristics and values of that area. So to my mind, Eco R5 does that, and it gives you provision too for a controlled activity, which actually is more lenient than the existing operative district plan, which memory is just makes it discretionary.
Okay, so then we move to Eco R6, and this is the bonus provision, and you've suggested a few amendments there, which on my first read of them seemed fairly self-explanatory and probably quite useful. So I'm grateful for you for thinking that through, and hopefully it's something we can have I'll have another discussion with Ms. Macbeth about later on. But apart from that, I really just wanted to talk through some of these issues with you, because you work in the space and deal with landowners quite a bit. So I appreciate that. Thank you.
Commissioner Coffin. Good afternoon. I've just got one question for you. This is just in regards to your paragraph 15. And there's quite a lot of quite helpful advice to us about the definitions and the use of the plan, and especially with your experience with the operative district plan and this issue about whether it's significant water body, a scheduled water body, or your preference for a priority water body. And wondered if you had any more thoughts, because I've had a look at the different ones and I can see where there obviously could be some confusion about what exactly is being referred to, whether it's a significant water body, the scheduled significant water body, or the significant water body, or in current practice, the priority water bodies. I just wondered if you had any further thoughts with it.
So my main issue with the definitions related to the fact that water bodies is quite broad and it includes things that they didn't really want strips or controls to, and that's why they brought in the definition of natural water and significant. So my initial submission was, is a significant water body a subset of a natural water body, and that matter was clarified because, as I said in my evidence, there are two, if it was the case, there are now two rules that are actually contrary to each other. I think that's been clarified, hopefully suggested in terms of the wording to make it clear. The reason I addressed the naming, I guess, of the significant water bodies was because one of the submitters was concerned that it suggested that the significant water bodies, the other water bodies weren't significant. In the previous district plan, we referred to them as priority water bodies, and that was because the indication was that we wanted to get things like mountain to sea access along key routes, and so we were giving them priority. It didn't imply that they were more significant in terms of their values, but where the emphasis and acquisition of esplanade strips actually occur. And that's why I've forgotten your name.
Yeah.
The reporting office, sorry about that, senior moment. That's where the reporting officer suggested.
And railway, those poles.
Suggested removing the word significant, but then you have a schedule of water bodies, which takes me back to my original submission. The water bodies are way wide. It was just a suggestion that I thought might give clarity to why those ones are given emphasis. And fundamentally, my understanding, it actually is mountain to sea.
Thank you.
Thank you, Commissioner McMahon.
No, sir, nothing from me.
Thank you. And just around your 15, scope for this? Question to you both, maybe. These good ideas from a planning practice, and that's why we particularly appreciate your assistance.
I do feel I've got scope from the iwi submitter, so it's Ngāti Mutanga, and also iwi water submission, where they just didn't like the two-tiered approach, and quite a lot of confusion over what Schedule 9 does, so quite a lot of submissions on that. And there's also a submission that's sitting on sub S9 from Kaionga Ora, which would also is a really important matter to deal with Schedule 9 as well. So, and yeah.
You mentioned that to us when you introduced things, so
yeah,
you found some scope.
Yeah, we found some scope, and that's why I deferred the submission, because it does need to be heard with the submissions on sub S9, which is in the subdivision chapter. And I think it'll become clearer after that hearing as to what the purpose of Schedule 9 should or could be, and maybe the name could come out of that.
You're a submitter on subdivision matters as well? Yes, it's an area that you've had a lot of experience with. Is that right? Yes. It's an area it is complex, and obviously I think the team here has recognised the interaction and has been having lots of discussions with. Is Lauren doing that?
Nicola Lawrence.
Nicola, yes, gotcha. Yes, and that's already been issued, that 42A report just a couple of days ago. Yes, Look, I don't have any other questions. I think that has been very helpful. Thank you for attending.
Thank you.
All right, last but not least for today, Mr. Rumble. Thank you.
Good afternoon.
Good afternoon. Right, the floor is yours, sir.
Can you blow that up a bit, please? Zoom in on the SNA. Zoom in more, please. That's right. More, please.
Give the transparency.
Focus on the SNA.
Other way.
Can it be outlined? Thank you.
There it is.
I'm against this particular SNA. And my reasons are that you look at the right-hand side of it, there is a fence that we put up 60 years ago to protect the forest on the right. And it's since been placed in a QE2 covenant. But to the left of that fence, which includes the proposed SNA in our house in time, it was paddock grazing cattle. The time we built the house, much of the clay fill excavation went into what is now that SNA. And although it's not clear about this phone.
That's fine, just
Someone's trying to get hold of you.
Yeah.
Although it's not clear from this photo, that proposal includes an enclosure and a shed, plantings of flax and small trees. And it's ecologically insignificant. That's all I have to say.
Thank you. Dr. Herbert's put a hand up, so.
Pardon?
Dr. Herbert's just coming forward. She's just going to respond, I think.
Yes, hello. We have actually made the decision to exclude the area of SNA that is on the screen from your property. So,
Hello.
yeah.
Now we can all get some sleep.
Job done.
Make sure that I'm clear, because in the hearing appendices for the recommendation, it says remove the portion of SNA from beside the rumble dwelling, etc. In the planning officer recommendations, amend the boundaries. So what you're saying is not amending the boundaries, actually removing the SNA.
I just asked Christine to zoom out. The situation with the Rumble property, it's also the parcel south, and most of it is in stunning, but if you could just go down a little bit more, Christine. Thank you. There's a small area that is SNA that is outside the QE2. I mean,
Okay.
I would be quite comfortable.
So it's not contiguous, there's different parts to it.
Yeah,
Okay.
it's just
Can
after the QE2 went on, it didn't quite align with the same boundaries as the SNA identified in the desktop. We have a lot of these little like slivers and yeah, probably be cleaner to remove it. It's it's cared for along with the rest of the bushes, but Mr. Rumble.
Sorry, I'm a bit deaf.
That bit down the bottom, it's cared for along with the rest of the bush, isn't it? That little bit, the little straggler down the bottom,
The part?
that bit.
Oh, yes, that's fine. Yep.
That's part of, that's managed along with the QE2 block, isn't it?
Yes, I have no problems with that. Yeah.
Okay.
Just the bit by the house. It's also a fire risk. if I allow regeneration to forests there, it's far too close to the house.
Thank you for coming along and sitting through. And
Okay.
it's been a good result for you by the sound of it, and supported by the logic from the experts. So thank you very much. And apologies that you had to sit through a long afternoon, but as I think I said, it's the way these things roll. We have to just, estimate the time, but really do appreciate you coming in. Thank you very much.
It's a pleasure. Thank you.
Right, before we have our karakia, I know that Kid has something you'd like to talk to the team about.
I've been, am I on? Yeah, I've been nominated to raise an issue with the team. Just hold on, where is my, yeah. It's not something we sort of really need to, it's more of a food for thought if council staff could have a think about it. It sort of comes from our working through these being the first district-wide chapters, obviously, where we've got some particular subdivision rules. This, I'm talking Eco 5 and Eco 6. And it occurred to me that the National Planning Standard actually requires that subdivision provisions must all be located in a subdivision chapter. And there can be cross-references if there are provisions that are energy, infrastructure, or transport related. So I did a little bit of trawling ahead, and I can see that we've got in at least 5 other chapters, about 17 other subdivision rules that don't sit within the subdivision chapter. And I'd just like council staff to think about that as a general compliance with the National Planning Standard proposition, and whether in fact there may be some benefit in terms of integrating how all of the rules, subdivision rules, might work if they all sat in the one chapter. I know it's quite a significant departure from where the plan has landed, but I think it's more structural than content. One of the other things I've noticed when going through the rules is that for at least 16 of those 17 other rules that exist in the other overlay rules or district-wide matters, they're all sort of expressed as a standard almost, i.e. if you are subdividing a site with feature X on it, for example, then you must also do, and then there's a range of things you do, either avoid, protect, maintain, or enhance the feature. So they're not subdivision rules per se, in that they don't entitle subdivision, or they're not a rule that leads to subdivision. They are a consequence of an application for a subdivision under another rule. And so to that extent, there may be some benefit in restyling them if they were to all come together into a subdivision chapter. So look, those are but the primary sort of question here is whether the staff have given thought to the National Planning Standard requirement that all subdivision provisions be located in a subdivision chapter, and if they could have a think about that and perhaps come back and have a chat to us about it at the right of reply. Is that the best way to deal with it, Stephen?
Yes, I think Ra's got a question.
Do you mean the right of reply for this hearing, or perhaps the subdivision chapter hearing? Because
I mean, yeah, I know.
Well, I didn't defer, but I did offer that perhaps because of the recommendation that Ms. Lawrenson's making, it's the rural area that it's a bit of quite a shift she's recommending, as I understand it. And
we haven't read. We haven't had a chance to read that, or Supercat may have, but I don't think.
Just thinking that through, to some extent, I mean, we're going to be looking at all of these provisions before we make recommendations at the end of it. If you think there is more affinity in us actually putting off any direct thinking about or calling to a close the submissions that relate to Eco 5, R5 and Eco R6, and then we bring them back into the frame when we do the subdivision hearing, then then I don't have a problem with that. It's not a matter we've discussed amongst ourselves, but if you think it's going to lead to a more integrated consideration of the subdivision rules across the board, and lead to some consideration of the question we've raised about the national planning standard, then I as one wouldn't be opposed to it. But I guess it's up to, we might want to have a chat about it amongst ourselves.
I would like in your verbal right of reply to have a chat with Sarah and the team and just give us your suggestions, like Kit's raised it. It's around I suppose it's this legal issue about the national planning standard. And I think what we're hearing is we're flexible about when it's addressed. And if we think it's better at the end of, as part of the discussions and subdivision chapter, which is looming up, we'd be happy to hear, but just come back to us, write a reply on this one and just give us your suggestions of how to handle that issue.
Sure.
Would be great.
Yeah. So I was going to ask you whether you thought there was merit in conferencing over the subdivision rules. I know in particular Helen and Stefan Kiss had some quite useful insights on the subdivision and SNA and being submitters on the SNA chapter.
I
that
think
would
so.
potentially be a separate conferencing.
Yes, ring
session.
fenced.
Yes.
But perhaps I should focus on the consent pathway, conferencing, vegetation disturbance.
Yes,
first instance.
certainly focus on that. But if you think there's a separate sub conference you can have on that, that's helpful. Again, come back to us next week.
Just can I just raise though that the other chapters that have subdivision rules are
Public access and waterbodies and
we've got some in the network utilities, we've got some in natural hazards, we've got some in historic heritage, we've got some in the notable trees, we've got some in SASM, we've got the eco, we've got some in NFLs, we've got some in water bodies, some in the coastal environment, and some in the public access as well. So we've potentially going to end up, because we've had to put off. I've got the hearing schedule in front of me, and I know that we've got hearings still set for where are we? Entrance corridors, view shafts, natural hazards, coastal environment, occurring before the subdivision. No, they've all been put off, haven't they?
Hearings 7 and 8 have been put off.
And then utilities and transport are after that, as are energy hazardous subsystems and all of that sort of stuff. So, yeah, I think it's the bigger issue. I think we need to get a landing on, I think, at the end of this hearing, because potentially if we think there's benefit in integrating a final consideration of the eco subdivision rules in the same frame that we're talking about the subdivision rules, then the same logic would apply to all of those other subdivision rules that are sprinkled throughout the other district-wide chapters, which are not going to be heard until after the subdivision chapter. So maybe it's a big problem that we're not going to be able to solve easily, but potentially just hold open consideration of these issues as we go through them towards the end. Stephen.
Yes, look, thank you. I think it's great to raise it as an issue. Rowan and Denise, you've got the gist of the issue.
Yes.
Yeah, have a chat with the team and come back to us with your thoughts next week when we're together again, or we may not be together by the sound of the rapid spread of our friend coming down towards us. Now, look, So yeah, are you okay with that?
Yes, so take that back to
yeah.
the team and come back to you next
Yeah.
week in the.
We certainly
reply.
appreciate the ability to, well, obviously we can ask you to do things, but it's great to get things on your table as we go through.
Sure.
I think we're ready for just a closing. Thank you, Antoine.
Aku nei te hono re whakakape e tātou hoi. He hono re he korore ki te atua he ngaro ki te whakaro pai ki ngā tangata katoa. Whai korore hara rui ka ngā mano mātua tama wairo tau ngā ngai. Tātou ki te kairi ki ware tira katori tua āmara te tīmatanga o te mātua tumata nei ka te māngai o te tau tuku mai a ea ki ngā. Māngai no po te toko tapu nā ki tia mai mātou i roto. Nō pai heri tia ki te rangi māringa wakatua ai a ea. Ameni.
Ameni.
Good everybody.
Kia ora, and thank you for everyone's assistance. See you. We may see you on the screen or back here again. I've had a discussion with Julie briefly that we'll respond to whatever the situation is on Monday.
I can't see them letting us out, Stephen.
No, not you. It's about whether we're
true.
we're paroled as well.
Yeah.
What's happened today? I know it's from the Waikato.
Yes, I think there's been some more cases, Kawhia, and sort of seems to be coming this way.
I saw that our mayor had said we're going to get Delta and
Not recording, yes. Yeah.
it's really his fault. It's his fault.